We'll move on to the Q&A, and let me see if there are any questions. I think there's quite a number, so let me see if they're going to get published. Have to wait a while. Okay, so maybe before the first question gets published, I might have my personal question to pose to Mr. Patrick. The question is, should I do my financial planning first and then followed by doing up my will, or should I do my will first and followed by my financial planning and update it along the way? Yeah.
Actually, you can do it together. No? There is no really which one should do first, because these are dynamic processes. Right, dynamic processes. Financial planning, estate planning, advanced care planning, these are things that you review from time to time. Right? It is not that after you have done it for the next 20 years, you don't do anything about it or until you pass away or something bad happens. Right? So these are dynamic processes, dynamic documents. So that means that you can do it simultaneously, concurrently together. Right? Because there's a likelihood that every couple of years you may have to review anyway. Right? So these are the things that you should do it concurrently. Right? You don't have to wait for one and not the other. All right, you can do it together.
Okay, thank you for that very good answer. Okay, the questions already have been published, so let me read out the first question. Do I need to have LPA overseas for my assets which are overseas? That is the first question.
All right. Okay, so okay, I'm not sure whether overseas they have this thing called LPA. I know in the UK, in Australia, in Canada, they have LPA equivalent. But honestly, in Southeast Asia, from what I know, right, I think we're the only country with lasting power of attorney. So it really depends on where your assets are. If they're located in the UK, then of course, I mean, I've seen UK LPA before or Australian. So if your assets are in Australia, then I would strongly encourage you to do your LPA there. But if in Malaysia or Indonesia, I'm not sure whether they have LPA there.
Okay, so I hope that answers your question for Mr. Tan, if I'm not wrong. Or maybe that's, yeah. Okay, so the next question is, will my insurance policies be included in my will? And if I have made a nomination for my insurance policies and included this in my will, would there be any issue?
Okay, first thing, you can include insurance policies in your will if you have not made any nominations for the policy. All right, that is clear. But if you have made nominations for your insurance policy, then your nomination will take precedence unless your will expressly revoke that nomination. Now, normally I would not advise my client to use a will to revoke the insurance nomination because it is very cumbersome and very messy, right? So you can revoke your insurance nomination by contacting your financial consultant to fill up the necessary form to revoke it, but don't use a will to revoke it, right? So to answer your question simply, if your insurance policy does not contain any nomination, your will can cover. If there is nomination, your will cannot apply to this insurance policy.
Okay, so the next question we have is from Lim. I think this is a very good question. His question is, how do insurance claims work with wills? So let's say if I die and I put my wife and children as my beneficiary, and I will my insurance payout to my nephew, will my will or insurance beneficiary take precedent?
No, then it's the same thing, because once you have nominated your wife, right, the insurance policy does not come under your will. It doesn't come under your estate. That's what we call it. What your wife will do is to approach the insurance company to make a death claim. Once the claim is processed, your wife, being the nominee of the insurance, will be paid out. Your will be separate. It will not include this payout to your wife, right? Your will include other unnominated insurance policy, which you are giving to your nephew. So like for me, I have 20 over policy. I only have one policy which I have nominated my children. The other 20 policies, I have revoked all their nominations. Once I have done that, all this policy money will come under my will. Remember what I've stated in my will, testamentary trust. Imagine I have nominated my children for this 20 policy. That is a good $13.5 million. What are they going to do with $13.5 million when I die? No way, man. I'm going to give them this money. They are too young to manage this. So what I've done is that I have nominated one policy, $500,000, for my 3 children. So the beauty of nomination is that they can gain immediate liquidity when I die. usually within 2 to 3 weeks, my children will be able to get $500,000. That is the beauty of nomination. But beyond this, I will not let them have the rest of the insurance money so quickly. It's too much money. So what I have done is that I have cancelled all the nominations for them. And once I've done that, the insurance money comes under my will. And remember, they can, under my will, they only get money when they turn 15, 25, and 30 years old. This is my planning because my children are still very young, right? So that is nomination. You have to know when to use it and when not to use it, and what is the purpose of nomination, right? So your will can basically include unnominated policy. But for nominated insurance policy, your will cannot apply, cannot cover. All right?
Okay. Due to time constraint, there's quite a number of questions here. Shows you guys have been paying attention. But due to time constraint, we'll just answer maybe the last 2 questions. So I see that there's one question here which is very good. May I know what is the cost involved in making an LPA or a will? Is it a one-off payment, or do I have to pay every year, or whenever I make an update to the LPA or the will?
Yes, basically this is one-time payment. If you make an LPA or a will, it's one-time payment. But of course, subsequently, if you want to make changes, for example, to your will, there will be charges as well. And the charges will depend on the complexity of your changes. So what they will do is they will give you a brand new will, and they will charge you maybe $100, $200, right? But what you get is a brand new will. But for first documents that you do with them, with us, there is a one-time fee. There is no monthly recurring fee or yearly recurring fee. It is a one-time payment.
All right. Okay. So we'll move on to the last question. And this question is, if I'm a Chinese Muslim, can I still make a will?
Yes, that means you are Muslim. Muslim, right? Your will is called wasiat. Okay, I know it's strange, but I do a fair bit of Muslim estate planning too, even though I'm non-Muslim. Right? If you are Muslim, right, you can do a wasiat, but your wasiat is basically limited. Your wasiat is guided by the Sharia law. In other words, under Muslim Sharia law, your wasiat you can only give in accordance to Sharia law. And as it stands now, you can only give 1/3 of your estate to non-Faraid members, meaning non-blood relations. In other words, in your wasiat, you can give to your friends, to Patrick, to Daniel, who are not related to you. But you cannot give to any of your blood relations. And if the other 2/3 has to follow Sharia law and the school of Islam that you profess, right? So for our Muslim friends, right, any of my Muslim friends, they don't just look at wasiat. They also look at other documents like a hiba or a Section 49L. You can talk to your financial consultant who invited you here about this Section 49L, which is an irrevocable trust whole life policy, right? This policy, if you have purchased, will not come under your wasiat or your estate to be distributed under the Sharia law. It can go, this 49L will go directly to your spouse and your child. So this may be one policy that you may want to look into, Section 49L, which I believe FLA will also have. Okay? All right.
All right. Okay. So I said that will be the last question, but there's really too many good questions here that, okay, I decide to have one more last question. All right. So the last question would be, if I do a will on my assets or insurance nomination, and so happen that my nominee dies with me in an accident, what will happen to my assets and insurance?
Okay, as I mentioned earlier, if your insurance contains nomination, right, your will not be able to apply. Will not be able to apply to this insurance policy which you have nominated. All right. So if let's say your nominee dies, right, then basically it's as good as no nomination. It will fall under your estate, and if you have a will, follow your will. If there is no will, follow the Intestate Succession Act.
Okay. All right. Thank you very much, Mr. Patrick. That was the last question. So before we end, I just want to ask, does Mr. Patrick have anything else to add on before we do the closing?
No, please take action. Okay, don't listen, really forget all about it, because I'm not sure when is the next time we are going to see each other or speak to each other, Take action and do financial planning. They must all come together. All right? Take care of yourself, stay safe, and stay healthy.
Okay, thank you very much, Mr. Patrick. And also, thank you everybody for joining this seminar. I hope every one of you has a better understanding on the importance of having wills and LPA in your financial planning process after this session. All right, so after we have ended, all of you will be sent a feedback form. And if you have any further queries, I believe your financial planner's contact details are there. So do feel free to contact them to find out more on how to do your proper financial planning, as well as to move into your wills, as well as your estate planning. All right. So I hope everyone has a great evening. Once again, thank you for joining us. Thank you, Mr. Patrick, for your sharing. I hope to see all of you at our next future webinars. All right. Bye-bye.